Something that I'm not sure the defense bar fully appreciates that we have to deal with as plaintiffs' lawyers, but hopefully can gain a greater appreciation for, is what we're dealing with and what we have to deal with in terms of liens. And that, although it doesn't come into what you do, it does impact on what an aggregate settlement you can do and what you can't do. Because when you are dealing with liens in a malignancy case from anywhere from $300,000 to $800,000, you have to deal with that. And there are new laws, even under Medicare, where the defense bar and the defendants really have to be aware of it. Now, up to this point in time, Medicare has taken the position, officially, that for cases that were pre-80 exposures, that they were not going to assert a lien. But for post-80 exposures, they were going to take an aggressive position. Well, as the paradigm starts to shift in exposures from the 50s and the 60s to the late 60s, 70s, and 80s, so will your considerations. And you're already dealing with Medicaid liens, workers' compensation. I'm just going to flag issues that you need to think about because it could be the subject of a whole nother seminar. But if you have a workers' compensation lien or your client brings a workers' compensation case, that may actually trigger a lien that you thought was asleep as it related to Medicare. And it's extremely important to understand those dynamics. So when someone comes to you and says, I want to settle all 50 of your cases, and there are 50 malignancy cases, you have to step back and understand exactly what you're doing. And you need to know where there are liens being asserted, where there aren't liens being asserted, what kind of money you have to escrow, what kind of money you don't have to escrow. For example, if it's a Medicaid lien, I don't know how many people actually have kind of suffered through this. If it's a Medicaid lien and there's an actual U.S. Supreme Court case on point called Arkansas versus Albone, which allows you to compromise the Medicaid lien if you can show that your settlement in your case is not for full value had you had the opportunity, for lack of all other factors, to get full value in your case. So then what happens? Bankruptcy issues come into play. And these are things we need to be aware of. I have a case that I just resolved in New Jersey. I hired a lawyer to deal with a special needs trust. I hired a former judge to help me with negotiate the Medicaid lien under Albon. And the judge actually had to go through the TPP procedures and give me estimates about how much more money I might have been able to get had the bankruptcy defendants actually been in the case. So these are all issues that you need to flag in your mind when you're looking at how you're going to settle the case. I'm not arguing against aggregate settlements. I'm just saying that, in fact, in some cases, they make a lot of sense, but you need to be aware of the issues, and the courts need to be aware of the issues that we're forced to grapple with on a regular basis. If you're not thinking about all these things, go home and read some cases. You'll lose 3 nights of sleep, I guarantee you.